and also viewing the defendant's motion related to the different areas, the remedies, I've addressed each one of those. So I'm going to deny it, but it's without prejudice because obviously discovery is ongoing and I don't want the defense to be under the impression that you can't bring this to the court's attention, or if it remains that I would then readdress it. Does that make sense?
It does. And I'm understanding the court's position. So if some new information comes about, we could refile this particular motion, not just asking for limine, but this particular motion since it's denied without prejudice.
Yes. So I think that the request for a jury instruction, that's not ripe yet. Or I have to analyze that under a different standard. Additionally, the request and the argument by Mr. Bias at the last court date to release her on bond, I don't believe this is the proper motion or vehicle in order for this court to review that. I've reviewed it based on the papers, reviewed it based on the Richardson analysis. And if you believe these things to, just like the rule says, 3.220 if there are things that remain, and I know the defense has brought several issues to the court's attention. Mr. Bias argued for a really long time, cumulative. At this point, I've analyzed it related to the issues brought to the court's attention. And I don't believe that there's a discovery violation. That's what I've found. However, if these things remain, if it continues, I want the defense to understand the court's ruling. You can bring it to my attention again. Okay.
And not to belabor the point, because I didn't ask this specifically, is the defense permitted to refile or renew the request for an Arthur hearing?
Yes, you can do whatever you feel as though is appropriate. I've addressed what you brought to my attention is what I'm saying to you. You understand? Like the discovery violations, there was, in my view, Mr. Bias was arguing the discovery violation / something that was not before the court. Does that make sense? Misleading the court.
I don't agree, but I do understand the court's position.
Okay.
Yes.
So I'm doing it without prejudice.
Thank you, Your Honor. And I believe that the next defense motion then would be motion to compel.
What's the state's position on that?
Is this the motion to compel subpoenas?
Yes.
I'm in agreement with providing discovery if it exists. I've spoken to my detective and am in the process of speaking with ATF. I believe that there was only one subpoena served, the one from Ms. Lucetti, which they're in possession of. At this point, I don't believe there are other subpoenas served, but I don't know that for sure yet. And if I find out otherwise, I will provide those to defense counsel. So I'll fulfill it if I can. If that discovery exists, I will provide it.
When will you know?
I'm supposed to have a call with ATF today. I spoke with Jacksonville Beach Police Department last week.
Okay. All right. So I'll grant that by stipulation. What about the motion for the transcript of Detective John's?
The state's objecting to the motion. I provided counsel with case law and I have some for the court as well. May I approach?
Yes.
Your Honor can review the cases. They basically state for the long-standing tradition of grand jury proceedings in our country are meant to be secret to ensure the integrity of the justice system. In both cases, Brookings versus State 495 Southern 2nd 135, which is the Supreme Court of Florida. The court does the analysis, and this is on page 3 of the opinion. There is no pretrial right to inspect grand jury testimony. While holding an in-camera inspection of such testimony is within the discretion of the trial court. The court discusses their decision in Gent, J-E-N-T, which is a cited case, that a mere surmise or speculation regarding possible inconsistencies in testimony is not enough to require the production of grand jury testimony. They discuss the importance of maintaining the secrecy of grand jury proceedings, and that the parties seeking the disclosure must make a strong showing of a particularized need in order to outweigh the public interest in secrecy. The other case the state cited, Bing versus State, 323 Southern 3rd, 830. In this case, the first DCA considered a request to unseal grand jury testimony, but denied it, finding that numerous alleged inconsistencies among state witnesses were an insufficient grounds to grant the motion, where defense is able during cross-examination to direct jury's attention to any purported inconsistencies between the witnesses. And also it analyzes a request to unseal grand jury transcript in order to determine whether the indictment was maintained upon perjured testimony. In this case, the court found that mere allegations of inconsistencies failed to provide a specific basis to conclude that a grand jury witness committed perjury, and the appellant could not seek a blanket production of grand jury transcripts based on mere surmise or speculation regarding possible inconsistencies. And that even when the state's case at trial differs materially from the grand jury indictment, there's no error in the trial court's refusal to dismiss the indictment. Court finds due process is implicated only when a prosecutor permits a defendant to be tried upon an indictment which he or she knows is based on perjured material testimony without informing the court opposing counsel in the grand jury. In order, the defense motion to unseal is merely speculative. It contains surmised allegations. There has been no particularized strong showing by defense that there has been any material perjury or any perjury whatsoever in the grand jury testimony of Detective Johns regarding the indictment. And for the reasons outlined in these cases, the state's going to object.
So, Your Honor, if I may.
Yes.
So in response, Your Honor, I looking at that first case, it's mere speculation that the state is claiming, first and second case, and that is not what we have before the court. We have a specific instance or instances of the lead detective before this particular court making false and misleading statements of material matters to this court. So now we are asking, based on what we know to be false representations of Detective Johns, for his testimony before the grand jury. Because if he's made those false statements to the grand jury, then we are moving forward on an indictment based on perjured testimony. The only way we can verify that, Your Honor, is to actually have the grand jury testimony. But what exactly are these false statements? The court's aware that they've received, that the state made a representation to Detective Johns about 3 checks. The checks initiated, or the funds allegedly initiated from the trust of Shanna Gardner. What the state did not argue or present clearly to the court as part of this misrepresentation is that the trust funds that they presented were from 2021. The checks to Tenon were in 2022, but it doesn't stop there. The funds that they showed from 2021, the balance on that very same check resulted in $1,900 and I believe it was about 25 cents. The check to Tenon was for $5,000. So again, clearly the funds that they're showing coming from Shanna Gardner's trust fund weren't related to the check that was provided to Tenon. The theory of the state's case is a murder for hire. The funds that they're showing aren't related. That's material. They also made a representation to the court of a truck that was driven by Tenon, and an allegation that only the individuals involved with the murder for hire would know about this truck. Why is that a problem? Because they failed to demonstrate to the court or show to the court that the roommate, Ordway, was well aware of the connection based on testimony or based on an interview by law enforcement. So these aren't minor or insignificant issues. These are material misrepresentations, whether it's the truck, whether it's the fund, but it doesn't stop there. And again, this is all through Detective John's representations to the court. There's the text messages that Detective Johns was well aware was based on a joke from some 20 years prior. And what did the state present to the court? Text messages, absent the context that this was a very old joke, absent the context that there was a text marked LOL. So to say that this is mere speculation when we can point to verified instances of misrepresentations by Detective Johns before this court, and knowing that he is the main witness, or at least it appears he's the main witness before the grand jury, his testimony has been perjured as we stand here before this court. So that's why we're trying to get through and get the actual testimony before the grand jury. Because if the case should proceed with this perjured testimony, Shanna Gardner's due process rights are in jeopardy. We are trying to have a fair trial and a fair opportunity for Shanna Gardner's case. So this isn't a fishing expedition. We're not asking for every witness that testified before the grand jury. We've narrowed it down to specifically Detective Johns based on his material misrepresentations to this court already. And it's a fair connection to say that he's made similar, or if not greater, misrepresentations to the grand jury. And the only way we're going to know that for sure is to actually get that grand jury testimony of Detective Johns. So for that reason, Your Honor, and based on all the argument that's before the court in this written motion, we're asking for the court to unseal Detective Johns' testimony, not for a fishing expedition, but to verify that this indictment that we're all before this court on is actually valid and not based on perjured testimony.
Can I just ask a practical question to the state? Why did you agree on other witnesses and you're not agreeing on this one?
Because I was fulfilling my Brady obligation, knowing that Ms. Jensen had withheld or given inconsistent testimony at another time. I have no such misgivings about Detective Johns' testimony.
So you're saying to me that you've reviewed the testimony, the grand jury testimony, and these areas that the defense is pointing out, these 3 areas, there is no Brady in the state's view.
I do not have Detective Johns' grand jury testimony because it's sealed. I obviously was present for it and have my notes from our pretrial and from the actual presentation of testimony, which was very significantly similar to the sworn affidavit he gave on the Title III wiretap affidavit, which they have possession of. I can't recall specifically these issues. I don't believe there was much discussion of some of these, but I can't say for sure. I haven't reviewed the transcript. But what I would say is they're talking about testimony that came out at a bond hearing regarding the detective's testimony on hearsay. So he's saying what other witnesses have said. We haven't deposed these witnesses. We haven't deposed Detective Johns. They haven't even asked him what he testified to at grand jury, or they haven't even asked him directly about these issues, vetted these out through discovery. So I think at this point, they're saying what they perceive to be misrepresentations, which I disagree with. I think that 2 parties can look at evidence differently, have different theories of a case and different theories of evidence. That's why we have a justice system and trials. They're saying that they believe Detective Johns' testimony is inconsistent with their theory of the case, and therefore there must be, or potentially would be, other misrepresentations in his grand jury testimony. That's a speculative statement without any specific substantive or particularized merit from the state's perspective.
You're on.
I think secondarily, if the court were to be inclined to consider granting the motion, the state would request that Your Honor do an in-camera review of the transcripts before releasing to either side. And if Your Honor perceives there to be anything that needs released, that those particular sections can be released.
I'm going to go back to my original question. So on Jensen, did you have the same information, that is your notes, and you made that analysis and agreed with the defense to
Yes,
release it?
So when Ms. Jensen testified at grand jury, she was reluctant to be truthful. She gave some statements, and then at a secondary meeting at the state attorney's office, she gave additional statements. So I believe that to be information that should have been brought to the attention of defense counsel, which is what I did. I had a phone conversation with Mr. Carodi. I told him that Ms. Jensen continued to withhold and continued to minimize her involvement, in my estimation, and that she had given us additional statements at a meeting subsequent to grand jury that she did not disclose at grand jury. And I believed that that meant, while it was not necessarily Brady because it did not tend to exculpate the defendant, but the fact that a witness gave additional statements that she did not disclose under oath, I believed that they should move to unseal the grand jury testimony. I told them so. It's in the email that Mr. Carodi that we entered at the last hearing. It's in their motion to unseal, and I had no objection. But in this case, their motion has presented nothing to the state that leads me to believe there's anything that they're entitled to receive that is.
This is, Ms. People, do you want to be heard? I think what I'd like to do is before, I'd like to read these cases, and I would ask that the state look at whatever testimony, make an analysis of what you believe, and I will take it up again. So.
If I may, Your Honor, just
Sure.
a brief point, just making that distinction in the second case, Bing versus State, 323 Southern 3rd, 830. And this particular case ends with because the defense conceded. There is no concession from the defense on this particular case or the material facts that we're arguing in this particular case. So I bring the court's attention to the distinction between the cases brought before the court,
Okay.
where we have the perjury and we're not conceding to the information that.
Do you have any cases you want me to read?
Other than what's cited in the,
Okay.
the motion, no, Your Honor.
I'll take this under advisement. I mean, maybe on a review, the state will change its position. If not, then I'll make the ruling. Okay. But I'm going to take this one under advisement. I've granted the other one. Motion to compel the subpoenas. I'm going to grant that by stipulation. What else is left for today from the party's perspective?
I believe that's all for the Gardner case, Your Honor.
Okay, Mr. Dreiser, do you have any? I have some things I want to cover.
The only update that I have is there was issue about deposing the children at the last court date. We have done that. Those depositions are done. So I just wanted to report that we were able to work all those issues out and get those depositions accomplished.
That's great.
And we have depot dates going back and forth for many different witnesses and different state, civilian, and federal witnesses. And I think we're working through the remainder of the discovery issues. And at this moment, I don't see any court intervention being necessary.
Okay. When are the depot dates?
We were kind of going back and forth on which witnesses this morning, but they're going to get set. They'll be witness.
I know. What are the dates though?
I don't have like the specific dates. We talked about October dates and November dates and December dates and whether we would do the federal witnesses in December. But if you thought that I was saying that I had dates, I just have the concept that we're going to continue depots each month moving forward.
On the federal witnesses, are they requiring a 2E request?
They are, and I discussed that with Ms. Stippo this morning, and she thinks this particular witness that we would like to depose the state will prepare the 2E letter and get it to him, and it should not be an issue.
All right.
It's the cast agent, Agent Blythe, and he testifies for our office all the time. We just email him a 2E letter from our office, and
And I would
it's
be,
very flexible.
if you need this, I'd be certainly, I would email you the depot dates that we select.
I would like those.
Sure.
When do the parties foresee this case being ready for trial?
Discussed that this morning for the first time, like the idea of getting a trial on the calendar was discussed. The only hesitancy that the defense from Mr. Fernandez's perspective has is we don't have all of the discovery ironed out at the moment. There's discovery, I think that's still being processed through the secondary taint issue from the first issues we've had. It seems as if there's some ongoing discovery. I think Ms. Stifler mentioned this morning that she was either about to release new civilian or seen witnesses or just recently did so. I will admit that I wasn't sure which one, but in my mind, the discovery is still sort of ongoing. Setting a trial of this magnitude seems premature, but the state had floated with no discussion with the defense agreeing, but August of next year. And I asked how long they envisioned the trial, and about a month is what I heard, a week of jury selection. I think they were saying probably 2 weeks for their case in chief. And I think they threw in an extra week, not knowing what the defense would call and who we would call. So I think that was a really generalized conversation. I'm not.
All right. We need a trial date. Okay. I know that you may think that it's premature. I think it's, it allows the parties to operate with some type of certainty. And it allows, with a case like this, it allows the court to make proper preparations. Additionally, on the capital side of this case, I know that you all are still working through the issues related to maybe guilt. A couple of things have come to my mind that, like, we need to, if you're going to file whatever capital litigation motions, I want those filed by the end of the year. I want to be able to work through some of those things, know where you all have objections, at least by the end of the year. So, yes, Ms. Peoples.
If I may, I would just ask if we could readdress this at the next setting. I know the Gardner team, we've got different schedules or different calendars to deal
Right.
with.
No, I'm
if
I'm not meaning to stress you out. Okay. I see the stress on your face. I'm bringing it up because it's never been brought up before.
Fair.
And I like goals. I like deadlines. So
if we
I'm
could-
putting it out there for you all, and however many lawyers need to get their schedules together. I know with lawyers, especially y'all, I need to book early and often, and that's what I'm going to do.
So
Okay.
could we do that booking, or could we even have the parties present suggested dates or suggested deadlines?
Yes, and we're not going to go too far in the future either. We're going to go like 2 weeks from now.
Or next
Yo.
month? It could
No, I'm talking like in a couple weeks. We are going to iron this out.
dates? Okay.
Yes, I want you all to be feverishly that's why I'm putting it out there. Okay, I'm not setting anything today. I'm going to set another court date. All right. So, Ms. Peoples, do not stress out. Okay. I want the state, okay, to take a realistic look at how you believe this case, how much evidence you're going to put on. I'm going to block y'all off. And it's going to be a while from now. Additionally, I'm putting these things out there. I want to know when you all believe that you can have your capital litigation prepared in order to submit to the court. Okay. I want to know from the state's perspective how long you believe this case needs to be tried. The question in my mind is logistics. Okay. Is there going to be an ask for sequestration? I need y'all to start talking about these things. Okay. And then additionally, when we get the jury selection date, realistically, with the logistics and the number of lawyers, how long y'all believe jury selection will take, if you want to utilize, how many jurors, things like that. I need y'all to start talking about those things. And we are, I know that you all have been focusing on the guilt phase, but we need to start thinking and setting court dates that are going to take up a lot of time, a lot of resources. So I cannot have this kind of just floating out, and we need to start we're rounding in my mind, maybe halfway point to, 3/4 of guilt. Mr. Dreiser, you're looking at me funny. I think that y'all can do it. Okay. And then y'all can set your deposit. That date should start informing how many depots, block setting, whatever y'all have to do to try to accomplish these things. Okay. And I need to get some type of gauge on where the defense is with any type of mitigation, if you need any intervention on the court. Okay.
Some information from you that I would request, and some information, if I may. I am out from the 4th to the 14th of October. We're going to take that into consideration for the next court date. Not that I have to be here, I guess Mr. Hill, Mr. Gisoni was Dave to handle it. So I just wanted to let you know that.
No, I'm talking like September 3rd, like next week.
And then, while it may be productive for the state and all of us to discuss these things together to bring, hopefully some consensus to the court, suppose it was a month, and suppose it was
What was a month?
the trial, the whole, suppose that's an accurate time frame. We all agree. Do you have any insight for us as to at the end of next year when you may have a month, so we're not?
I'm not booked out that far.
Okay.
And then this is a priority case, obviously. And so I would make whatever arrangements. That's why I need y'all to get together. And this doesn't need to just be something unsaid. So I'm saying it. I want you all to get together, and then I'm going to set, and then we're going to work towards it. And I'm going to give y'all whatever time you need so that we can get to it. Okay. But I'm not booked out when y'all are setting or saying. I'm not booked out that far. So I can give you all the time that you need. And if I will avoid it, I'll avoid the a week or two prior to setting days aside if y'all want me to do that. But we need to start looking at that. Okay. That's what I wanted to bring up.
Yes, Your Honor.
Anything else?
No, Your Honor.
No, Your Honor.
With defense counsel.
Okay. All right. I'll see y'all next week.
Thank you.
What day? I can do Monday. That's exactly a week. Do you want that? Or I can go in a little bit further in the week if y'all want more time. That's fine.
Whatever you guys want.
Wednesday.
Sorry.
I'm sorry. I didn't hear.
I'm sorry.
I'm sorry. I didn't hear that you had said Monday. I know you said next week generic, but it's like
No, next week.
if Miss Peoples and her folks do Wednesday, that'd be better.
No.
No, it's.
Oh, it's not coming up.
Sorry. Should be fine, Your Honor. I can't.
If you need a minute, I can set it when you're ready.
Wednesday.
Give it, Mr. Dryson. Give her a second. All right.
You do. So we're looking at October 2nd. Sorry, October 3rd, Your Honor?
September, next week, Miss Peoples. It's the 30th, the 1st, or the 2nd.
Someone will be here.
Well, I don't want to set something when you all don't have the time.